All right, we're going to go over the rest of the chapter before your final. And so this is where we left off. Let me just back up here. This is where we left off from last time. Because remember, and I'm just going to go back here to another slide just to kind of give you a brief review over where we left off and to how we're getting into where we are right now. And the last thing that we discussed was granting that petition for review. And one of the things, and it's not mentioned here, but it needs to be, was that you have to have that rule of 4. So it's not mentioned here on the slide, but I did put it on the board for your notes, and hopefully you wrote that down. So remember that you got to have the rule of 4 so you can have the writ of certiorari. And you need the writ of certiorari so you can have the case. And there's a really good point here at the bottom of the slide where it says most of these reviews are denied. So granting writ is not exactly ordinary. It doesn't happen a lot, and we'll talk about that. That plays into something that we'll get into towards the end. Get into it here. We're picking up where we left off from class, and so we get into the Supreme Court's procedures. And so let's understand that, the justices are going to do an awful lot of research on this, and they'll rely heavily upon their clerks to do this. So, Supreme Court justices have about 3 or 4 clerks, people who work for them, to do their research, to find aspects there on the record, to find previous decisions, to read outside groups. Yes, that will happen here. And they'll provide them with a whole host of information for every single case that they're going to hear. That said, when they get into the courtroom to hear a case, here's how this will shake out. You'll have your 9 justices up on a dais, and they'll all sit there on the dais. I want to say the prosecution starts, and they get 30 minutes. So they go up to the lectern and say, "May it please the court," and then they begin their argument. And so they'll get about 30 minutes to do that. The problem with that is that they get about 10 to 15 words in before one of the justices interrupts them and begins to ask questions about what their case is, about what they're arguing, about the issue. And that's how those 30 minutes is going back and forth with a justice or justices, okay? It's interesting when you listen to this. It's really cool. So you have this argument taking place, and then there's a light that will go off, and then now your 30 minutes are up, and then you have to sit down. The other side goes and does the exact same thing. May it please the court. The light goes on. Then you start your 30 minutes. You get and to have this interchange. Like it's pretty neat how this shakes out. All right. A couple of things that I wanted to mention in the slide, and so you'll have to listen to this in order to get it down, is that oral argument, as you can see up here, this is on the slide, so you have this for you. Oral argument is how the business is conducted inside the Supreme Court. So when they do their day-to-day things, when they're hearing the case, it's through oral argument. So, and the reason that we can listen to these oral arguments is due to the fact that the audio is recorded, there is a sketch artist, and there's a stenographer who will type out all of these things. And so you get everything short of video being recorded here, and video is not allowed. And you may wonder, well, you got everything else here. Well, why not have video? Well, the reasoning behind you don't want video, the reasoning behind that is the justices don't want a lawyer or anybody else, or even themselves, to play up to the camera. They don't want to turn the Supreme Court into the TV show The People's Court. They don't want to have a justice playing up to the camera for a soundbite like someone like Marjorie Taylor Greene or Lauren Boebert or Alexandria Ocasio-Cortez or any of those particular people who you can find on social media and hear what they have to say for 5 or 6 or 7 seconds, and that just goes on this loop. The courts don't want that. They don't want anyone to really have that. So they have an audio. They have a YouTube page. I don't know if y'all knew that. You can actually listen to this as they are going, excuse me, as they are hearing the case live. You can listen to the YouTube page. And you can see, you can just, listen as they go along. So there is recordings being done. Let that be clear. But there's no video. All right. So what happens next is after they're done hearing that case, they adjourn to a small room where only 9 of them will be. And from that moment, that's where they decide the case. They may say, well, how do I know that? If there's no public record of this, how do I know that it happens? That's a fair question. Because former justices like to write books and like to tell as to what happened, and they will give this off. And there's former clerks who will also tell what happened. So this is how we know. People who are there will tell us. And that's where they decide the case, right then and there. Okay? Interesting. And now you have to make your decisions, and then you have to write your opinions. Okay? And this is our next section here where it says that the opinions that we're going to go over, these are written opinions that contain the court's ruling. So this is how they rule. Excuse me. They'll state the reasoning for the ruling and how the applicable rules of law. So they'll explain all this stuff in a majority opinion, and then you'll get a few other opinions that we'll discuss here too. So let's understand, but before we get into the opinions and all that, the types of decisions that exist. And so the first one that we like to really begin with is affirmed. Affirmed simply means that the lower court, now remember, the Supreme Court behaves 90% of the time as an appellate court, meaning 90 times out of 100, it's hearing the case for the 3rd time or the 5th time. I mean, it's not the first time it's hearing it. So they're hearing this case several times. Okay? Well, I'm sorry. Scratch that. They're hearing the case for the severalth time, if that's even a term. Maybe I just made up my own word there. But they're hearing the case that came from a lower court, and they do that 90% of the time. So they have to have the lower court's record, and if they affirm the decision, if the decision is affirmed, then what that means is that they have upheld the lower court's decision. They've upheld the lower court's ruling. If they reversed it, if the court reverses, if the decision is to be reversed, that means that the Supreme Court overturned, the lower court's ruling. That's what that means. Okay? And then the third type of decision that we'll look at here is called remand or remanded, as it says here, as it reads here on the slide. What that means is that the court will say, okay, this has to go back to the original district court because it didn't do ABC. And once it views the case through ABC, then we have the right channels that they really need to review this. So they send it back to the court of origin, where it all started, with directions on a retrial. That's exactly what a remand is. So you talk about starting over. You can see how that can be a little frustrating. But those are the 3 types of decisions that you hear from the court. Now, with those decisions come the opinions. And so you have the first one here being the majority opinion. And the majority opinion, let's understand here. I guess what I need to say before I even get into this. This isn't like someone's opinion on the weather or someone's opinion on lighting or someone's thoughts on a painting. All right? So, those types of things may carry weight for some people, but for most of the people, they don't. It's just like involved in some sort of a conversation. That's not what we're getting at here. An opinion from the Supreme Court means that that's how they're explaining their ruling. That's how they are issuing their ruling. This is their interpretation of what you asked that falls in line with one of those sources of the American law. Usually the Constitution. All right? So let's understand what we mean here by opinions. I just wanted to make that very clear. It's not like you're asking me my thoughts on newspapers or magazines or social media. That's meaningless. I mean, it's just a thought. But if you're asking someone, the Supreme Court, to weigh in, and they hear your case and they issue their opinion, that's law binding. All right, that's very much law binding. Okay. That cleared up. This is the official ruling of the case that does have the full weight of the law. So how does one write an opinion? How is that even chosen? How does that even come about? Well, I tell you right up here that the author is chosen by the Chief Justice. Now, we haven't talked a lot about the Chief Justice, but understand the Chief Justice is the one in charge of the Supreme Court. This person is also in charge, in large part, of the entire judicial branch. That said, what this person will do in this capacity, if the Chief Justice is in the majority, meaning he's part of the 5, he's part of the 6, he's part of the 7, he's part of the 8, what's called where he will he'll just simply choose someone. He'll just choose someone to do it. All right? He'll ask someone to do it. So the Chief Justice will choose someone. He usually chooses himself. Okay? Let's make sure that we understand that. He usually chooses himself. And what if he's not? What if he's not in the majority? What if the Chief Justice is in the minority? Maybe he's that one person. Maybe he's one of the 2. Maybe he's part of the 3 or the 4. What happens then? Well, he can't choose. He can't choose the author. So what happens in that case is, if the Chief Justice is in the minority, the longest serving member in the majority will choose the author. Okay? So, and again, that person will usually choose him or herself. We always need to remember. We always have to remember that these justices have egos, and they're healthy. They are very healthy egos. So don't think that they're, being all truistic with their choices and all. I mean, sometimes you can't really dismiss it. That's never the case. But just remember that these people have egos the size of Canada and Russia and North America all combined. So it's kind of amazing. There's another type of opinion that we need to look at. It's called concurring. And what concurring means is that someone who agrees with the majority opinion. And so this person is going to state why they agree. Now, they'll agree with the end result, but they may have gotten that, they may have took another path. They may have taken another path to get to that spot. And they want to explain their rationale, his or her rationale, for getting to that majority opinion. It may not be exactly the same rationale that the author of the majority opinion got there, okay? So it's like, think of this as a math problem. You're showing your work. Yeah, we got to the same result, but we had a different path, and I want to explain how I got to mine, okay? That's what concurring means. Of course, the most interesting one, honestly, is dissenting. The dissenting opinions, as you can read here, is where they disagree with the majority. All right? And when they dissent, when judges dissent, these are just fascinating things. They can be very, very long and very much detailed. And so it's really cool whenever you see a very long dissent, because this can actually be the legal basis for future cases. So, in like 15 or 20 years, you may have somebody go back to a particular dissenting opinion and say, Justice so-and-so in case yada yada versus yee yee wrote all this. And they say this is based on law. This is based in fact. This is based in everything. And we need to re-examine this on these grounds. It's been done before. It'll be done again. So there's one more opinion that I don't have up here. And I skipped it in an earlier class, and I'm beating myself up because I'm just now remembering it. It's called unanimous. It's a unanimous decision. It's a unanimous opinion. Unanimous means there's no dissent. Okay? It's 9-0. No dissent. 9-0. That's a unanimous opinion. Okay? When there's uniform in this, when the Supreme Court is in one accord, that's a pretty big deal. All right? We've been seeing some of that in the last couple of Supreme Court decisions. We've been seeing some unanimous rulings, and it's like kind of eyebrow raising, like The Rock. If you have a GIF and you type in The Rock eyebrow, that's the kind of reaction that I get. Well, that I give anyway. Like, oh, what was this about? Maybe we need to see what they're all agreeing about. Huh. See? Okay. So, while it's not on this slide, you do need to remember that there is a unanimous opinion, and there's no disagreement. Okay, there's no dissent. 9-0. Marbury versus Madison was unanimous. Brown versus Board of Education was unanimous. Okay. All right. That said, let's move on here to the next slide where we talk about publishing the opinions. Okay. And just to let you know, I'm recording this at home, and so you may hear some sounds. It's usually my dog, or you may hear a cat come up on my desk. I'm going to talk through it, and so just a disclaimer that if that happens, no animals being hurt, no animals or pets were harmed in the recording of this lecture, even though they may give me their own type of viewpoints on my jokes, but they have to live here, so they got to deal with it. Just wanted to let you know that in case you hear something and now you know what's going on. Okay, so when we publish opinions, when they're being published, they're officially put in the publication called United States Reports. I often like to look at what's called SCOTUS blog. I think SCOTUS blog is one of the coolest where you can find those things. And I say that because former clerks for Supreme Court justices work SCOTUS blog, like they run the site. And what they will do that I think is the coolest thing around is that they will give the PDF of the decision, and then they'll explain the opinion in plain English. I can't tell you how incredibly helpful that is. Because it is, it is. So I like to use SCOTUS blogs. It's called scotusblog.com. It's spelled SCOTUS blog.com. And they don't pay me for any sort of publication or promotion or any of that stuff. They should, because I promote them every semester. All right. That said, we do need to know that the court just isn't hearing as many cases as they once were. I mean, truly, it is a dwindling caseload. They're not hearing nearly as many cases as they used to. Like, here's some straight facts straight from your book. Go back to the 82-83 session. The court issued over 150 cases. Issued opinions on over 150 cases. And you think, okay, that's all right. That's almost 3 times more than what they heard in 2022 in the 21-22 session. All right? I mean, 63 cases, and contrasting that with what happened in the early 80s is peanuts. That's pretty small. Now, look, I don't know the reason. Okay, I can't give you any insight on the U.S. Supreme Court as to why they're not hearing cases anymore. It may have to do with philosophy of the court. It may do with the fact that they're old. I'm not telling you anything you don't already know. It may have something to do with, I don't know, their willingness. So lots of things that we can consider here. I just can't give you a one direct answer to a question why they're not hearing as many cases as they used to. I don't know. But I can give you some ideas. But if I was to place the answer with one particular option, I would say it's got to be the court's philosophy. Okay? And we'll talk about that a little bit later here. All right. Now, we're done with the Supreme Court at work. Okay. Now we're going to move on here to how judges are selected. And it's a fairly straightforward formula here. I mean, this isn't going to this isn't reinventing the wheel. So hopefully this isn't groundbreaking information to you, as it comes out of straight from the comes straight from the Constitution, where the president nominates someone, and the advice and consent part that the Senate plays with the president. They advise and they consent, and this is what they get to do. Okay. The slide says here that candidates are suggested to the president from various sources. That's true. That's true. We got Alana Kagan on the U.S. Supreme Court because of Antonin Scalia. He may have had dinner with then President Obama, or maybe he wrote him a letter. There was some sort of correspondence, some sort of words exchanged here, and Scalia said, you're not going to really appoint anybody who I always agree with, but I think if you're looking for a brilliant jurist, Solicitor General, she is nothing short of brilliant. And President Obama did that. He nominated Kagan. She was confirmed, later in I want to say 2011. So, you can get suggestions from anywhere. Groups will do it. Senators will do it. Past presidents will give suggestions. All type of things. Suggestions come from everywhere. But the process goes: the president formally nominates, and the Senate takes up the nomination. All right? Now, let's understand here that that's supposed to be that way. The Constitution doesn't say that the Senate shall take up, and that's going to play into a role just a little bit later. So what about the judgeships that aren't the Supreme Court? Because let's understand that this formula right here is the way it is for all federal judgeships. We don't elect our federal judges. Now, I'm not saying that's a bad thing. I'm not saying that's a good thing. I'm just saying that's a thing. So because they're nominated and confirmed, the Supreme Court that's done that way, it's the whole federal judiciary. It's the district courts. It's the courts of appeals. It's FISA courts. It's all types of federal courts that exist. They come through the president, and the Senate confirms. Okay? So for federal district courts, these are the trial courts, and so those judges have to be nominated by the president, appointed by the president, however you want to say it, and then confirmed by the Senate. What this president will do here, at least he should, is this thing called senatorial courtesy. And what this means here is that the president goes to the senior senator from a state, and they discuss a potential nominee, right? So let's say, for instance, in the Northern District Court, which of Texas, say there's one, say that would be this area in which we live, the Northern District Court. And so say President Biden goes to the senior senator of Texas. That would actually be John Cornyn. John Cornyn has been the U.S. Senator since 2003. And if he goes up to Senator Cornyn and says, hey, I'd like to nominate yada yada for the Northern District Court in Texas. What do you think? John Cornyn has one of two options. He can say, yada yada, I've known them. I don't always agree with them, but they're a really good judge, and I think they'll do a great service. I have no problem with that nomination. And then the president would continue on with the nomination. Okay. The other way that could be done is where the senator says, no thanks. I know, like, let's say, okay, hey, Senator Cornyn, I'd like to nominate yada yada. And Senator Cornyn goes, I know yada yada. Yada yada is a dirty, rotten bastard, and I'm not going to have that person be a federal judge. No thanks. Okay, well, thank you, says President Biden. I appreciate that. Do you have any other suggestions for a replacement for Judge yada yada? I certainly do. I'm so glad you asked. Here's a suggestion for such and such, and here's 4 or 5 other suggestions that I have no problem with. If you pick any of those, I have no problem with that. Now, you can see here on the slide such an action gives senators a lot of power. That they could essentially, as it says here, veto judicial appointments that would be in their state and say, nope, don't want that person. And yeah, okay, I mean, I can see how that has constrained presidents, but so what? That doesn't, I don't see, I'm not seeing an issue here. What I'm seeing here is presidents and senators who don't want to work together. Now, that's a problem. That said, understand that senatorial courtesy, nowhere in Article 2, nowhere in Article 3 does it say that the president shall conduct senatorial courtesy with senators over federal judges. Nor does it say that anywhere in Article 1. So it's not constitutionally required, but you know what it is incredibly helpful. Courtesies are not required. Okay? Let's be clear about that. That's why it's called senatorial courtesy. So it's not required to do, but it is sure as heck helpful. I often like to say that I don't know how close you may be with your parents or a sibling or any other sort of family member, but you're not required to call them. All right? But you know what? It sure as heck makes life a whole lot easier if you do. If you maintain a continual conversation with your parents or your siblings or any other family member, makes life a whole lot easier. All right? And so, cultivating that relationship and keeping it alive is pretty easy to do if you talk to them once a week or twice a week or 3 times a month or whatever the case may be. Not required, but helpful. Same thing here for senatorial courtesy. All right. Let's move on here to other sorts of appointments. All these things are fine and good. I'm not real too concerned with courts of appeals and all that. But what I am concerned about here is the partisanship. And this is where we get to deal with Congress. And this is where we get to really discuss legacy, and we get to discuss other aspects of the president's agenda that have to do with judges. All right. The longest-serving Supreme Court justice is Clarence Thomas, and we'll talk about him a little later. Thomas was appointed in 1991 under President George Herbert Walker Bush. President Clinton, his judicial Supreme Court judge appointments are gone. All right. President Reagan's are gone. Ford are gone. Okay? The ones who are still there are H.W. Bush, W. Bush, Obama, and Trump. Oh, and President Biden. So the point I'm making here is that judges are part of a presidential legacy. Not to say that the judges themselves are in a political position in a partisan manner. I don't mean it like that. Excuse me. But what I mean is they're part of that legacy of the president who appointed them to that position. Okay? So, they say here, the slide says that this is a way for presidents to institutionalize their political views for long after they left office. There's truth in that, but that's not what I really want to talk about. What I want to get into is the Senate's role in all this and dealing with confirmation. So they have to confirm with a majority vote. So they have to have a majority vote. Okay? And what I'm talking about here is they got to have 51%. They got to have 51 senators to say, want that person. All right? So, have there been some controversial Supreme Court nominees? Absolutely. And I'm giving you 3 right here. I don't really consider Harriet Miers to be that controversial. We'll talk about her. I'll mention her here. But Robert Bork, when he was appointed in 1987, President Reagan put him there because he being Bork, was a known conservative. And Reagan was a conservative president, and he wanted a conservative Supreme Court justice. Makes sense, right? Of course. So, that said, the idea here was that maybe they would, the Senate would consider Bork for his credentials. Now, is that what happened? Well, Bork was viewed as somebody outside of the mainstream. He was viewed as truly an extreme person. Now, that may or may not be fair, or may or may not be correct, but that's how he was viewed. And what happened here was that it was his perspectives on civil liberties, like privacy or civil rights, women's issues, those types of things is what got him into some trouble with you. Well, from that, what we saw was he was rejected. And hold on just a second here. I gotta get. Sorry for that. I don't know what this is about. So, he was rejected. Well, then President Reagan put up another nominee, and then they had to pull him out. Like, they had to stop the whole nomination process because of something in his past. But then they found Kennedy, and Anthony Kennedy was confirmed with glowing numbers in 1988. Daggone it. I am so sorry for these mishaps here. Well, Clarence Thomas gets appointed in 1991. Okay? And Thurgood Marshall, who was the first African American to serve on the U.S. Supreme Court, he was appointed by Lyndon Johnson. Thurgood Marshall retires, and he says, I'm old, I'm tired, I'm going home. He does that in 1991. Well, President H.W. Bush appoints another African American, and his name's Clarence Thomas. The issue here with Clarence Thomas was that he was a known sexual harasser. And so the person who was coming forward and stepping up to say he sexually harassed me was a woman by the name of Anita Hill. And you can actually find her testimony on YouTube. All right, you can do a search for Anita Hill testimony, and it's tough. It's a pretty rough thing to listen to. It's not easy, so you have to be really prepared for that. But the things that she says are very graphic, and it looked like support for Clarence Thomas was going to slip until he turned it around, and he said this is nothing more than a high-tech lynching. And that kind of turned the tide on him, and he was confirmed 52-48. All you need is 51. Everything else is for ego. So, but he got 52. Now, I want to go back to Bork just for a second, because the legacy of Bork is that his last name is turned into a verb. they'll say borked. You don't want to get borked. Now, what on earth is that? I can see why you'd be like, well, why do I care about that? Well, what borked means that you've been politically vilified, okay? That people have, or the narrative around a nominee is to where that person's sort of a comic book villain or something like that, that they're some sort of an evil person. Like Kingpin from Spider-Man or Daredevil or something. You know what I mean? Borked. Don't get borked. Talking about don't let anybody control the narrative. Now, there are people who very much are on the side of Judge Robert Bork. They bear his scars, and the man's been dead for well over 10 years. But they bear his scars and say, he was really screwed over. Those Senate Democrats, they launched an ideological attack on him, and they view Bork as a martyr of the increased polarization. And that's personal political philosophy. I'm not touching that. I'm not even going to get into that. But the most objective thing I can tell you, because this term is very important, okay? And so it would be a disservice if I didn't tell you what it was. But you need to know what it is, and so the best definition I can give you is that it's the political vilification of someone. And that's what happened here. And so with Bork, he was denied, he was rejected, and his followers, his big supporters, said how, this is such a terrible day, and they still say stuff like that, But that's the issue there with Judge Bork. He was very controversial. He was actually the last person to be rejected by the Senate. If they get that close ever again, what they'll do is just remove that person from consideration. And that's what happened here with Harriet Miers. Harriet Miers was President W. Bush's first nominee for the Supreme Court before he decided on John Roberts. But what happened here with Harriet Miers was that she was often viewed as something like, some people called her like the cleaning lady. Like she didn't really have any big success on a resume, or it just wasn't measuring up. And her meetings with senators were not going well. And so what he ended up doing, what he being President Bush, W. Bush, ended up doing was removing her from consideration. I don't know if that's so much controversy, but she's often mentioned in that whole conversation. I wouldn't put her there, but I get it. All right. So another big thing that happened here was in 2016, where Justice Antonin Scalia died. And it was a shock. It was a tremendous shock. Nobody saw this coming. It was, he never complained of not feeling well, or he always seemed to be in relatively decent health. So for his death happening in February of 2016, it was like, oh, wow. Now, President Obama was still in office, even though this is a presidential election year. And he nominated Merrick Garland to the U.S. Supreme Court to fill Scalia's seat. This happened because of Nebraska Senator Orrin Hatch. He actually said, we might consider somebody if the president was to nominate someone like Merrick Garland. So he didn't just go with someone like him; he just went with him. And so Merrick Garland gets the nomination. And what happens here is the majority leader, Mitch McConnell, in February says this is a presidential election year. We shouldn't be the ones to decide this. The people should. And so we're not going to take this up. He said, the president and the majority of the Senate are of two different political parties. This stuff, it's just structurally wrong. We just can't do it. That made everyone go, what? So the end of the 2016 session, the end of the 2015-2016 session, had 8 justices. 8 justices. That's pretty surreal. And so, President Obama kept calling for people to call on Leader McConnell, call on the majority leader to give the man a hearing, give Garland a hearing, at least that. But that didn't happen. And this is the influence, the power of the majority leader in the U.S. Senate. This is why this position is so incredibly powerful, because Mitch McConnell has turned it into to where he actually stopped a Supreme Court nominee. I mean, that's pretty awesome. That's part of Mitch McConnell's legacy. Brett Kavanaugh, well, back up from that. So when, the whole conversation was, if Hillary was to win in 2016, this would turn into where they would probably hurry up Garland's nomination process and put him in. But that didn't happen. Trump wins. Garland goes back to being a Chief Justice at an appeals court. And then about 10 days into Trump's presidency in 2017, he nominates Neil Gorsuch. Okay? And Gorsuch is confirmed by midway through the spring. I mean, it was an astounding achievement for Mitch McConnell and President Trump. So when Anthony Kennedy, who I mentioned earlier, retired in 2018, spent 30 years on the bench. When he retired, President Trump nominated Brett Kavanaugh. And lots of controversy here. A lot of it had to revolved around a sexual harassment, sexual assault case of someone who he went to high school with. Her name was Dr. Christy Blasey Ford. And you can find testimony, you can find all this stuff on YouTube. I'm not telling you anything that doesn't exist. But what's interesting here is that Kavanaugh tried to turn it backwards on him. And he is actually confirmed. 98 senators were there for the vote, and he's confirmed 50 to 48. Okay? Very, 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 very close vote. But the one that really took everybody by surprise was when Ruth Bader Ginsburg was, when she died in September of 2020. Now understand that's 2 months before the election in 2020. Ruth Bader Ginsburg she passes away, loses her battle with cancer. But you still have President Trump in office, and you still have Mitch McConnell as the majority leader. And what we saw here was Mitch McConnell just take a whole different turn on the whole thing that he did 4 years prior and say, we can do it. We can put this person in. Again, when you have the power, you use it. And McConnell was no different here. Now his rationale about all this, because this was thrown in his face. He says, well, what's the difference between now and 4 years ago? And basically what he said was, we have a Republican president. So that's it. End all be all. I mean, he did some word salad. He tried to do some mental gymnastics, but it was a gold medal performance of his mental gymnastics, by the way. But that's neither here nor there. But the truth of the matter is the fact that McConnell says, is basically saying that they have the power and they're going to use it. Okay, no problem. Now, one of the last things that we're going to talk about here is what's called judicial review. And judicial review is all about an ongoing issue that some people say, really isn't a power of the Supreme Court. Okay, it's never fully defined in the U.S. Supreme Court. And that said, excuse me, sorry that I hit the microphone there. What it says here is that it comes from Article 3. At least those who say it's a perfectly fine power to have, they'll point to the fact that it can be an implication. It can be an implied power. And so even though it's not explicitly stated in the Constitution, The argument is that it's implied because it says the judicial power. And you have a good question here that you can ask is, well, what does judicial power mean? Well, the Constitution doesn't exactly define judicial power, but you would imagine that it has something to do with interpretation. Well, all that said, what we have come to learn as to what judicial review is determining the constitutionality of laws passed by Congress or acts by presidents, and even laws that are passed at the state level and constitutions at the state level. Okay, this is a pretty big deal. So that said, I mean, the fact that that the court has the authority to determine this, the constitutionality of something, this is quite the big deal. And how it came about was due to Marbury versus Madison. Okay? Now, I want to be clear about a couple of things here when we talk about Marbury versus Madison. We're not going to go over a complete case here of what Marbury versus Madison is, and I don't have a full expectation of you to get the finer details of all this. But what it all boiled down to was called the writ of mandamus. The writ of mandamus. Okay? Mandamus is spelled M-A-N-D-A-M-U-S. Mandamus. Spelled M-A-N-D-A-M-U-S. Mandamus. And what the writ of mandamus is, is that it was a power that Congress gave to the courts. I want to say in the Judiciary Act, maybe of 1791, maybe of 1793. You can find the year if you want. That gave the court the ability to decide it gave the court the ability to mandate, to force two equal subordinates to do something. Okay? It could force one of the two to do something if you sued under it. If you sued somebody under the writ of mandamus, judge, tell him to do something. Okay? That's what it is. So, how'd this come about? Well, look. Long story short, Adams loses the re-election of 1800. He puts a bunch of judges on the federal judiciary. Half of them don't get delivered. Part of that half that didn't get delivered was William Marbury. James Madison is the new Secretary of State under Jefferson. Madison asked Jefferson what to do with these Adams appointments. Jefferson says, "Don't do anything with them." And so Madison is not going to deliver the appointments. Marbury sues Madison under the writ of mandamus. It goes straight to the U.S. Supreme Court. And John Marshall, who's actually part of this whole thing, he was appointed by John Adams to be Chief Justice, and so that's how he's there. Anyway, he eventually says, I can't do that. I can't force anyone to do anything. I can't, because Marbury is suing Madison under the writ of mandamus to force Madison to deliver the appointments. Okay? And John Marshall says, I can't make anyone do anything. I can't do that. So I can only interpret. But what I can tell you is the writ of mandamus is unconstitutional. And that right there is where we got judicial review. Okay? And so we point to Marbury versus Madison as the beginning of the court's check and balance on the other branches. Okay? Now, as we go back here and we think about how justices have used judicial review, we have one thing called judicial activism. And one way to really sum up this definition, this little small blurb, is to right the wrongs. That's how you can sum this up. That if the state has wronged you, if Congress has wronged you, if your governor, the president, if another court has wronged you in some mechanism, sue them, and we will take on that case. That's what's called judicial activism. Okay, that's judicial activism. Judicial restraint is the complete opposite, to where you believe that the courts shouldn't do that. That they should defer more to elected officials. That you should defer to that your greatest influence, according to judicial restraint, is that our influence as citizens is greater with Congress people, state lawmakers, mayors, city council people, governors, senators, because we elect them. And so because we elect them, our influence is greater with them than it would be with the courts and federal judges, because they're appointed. So don't come to us first. Come to us when you have exhausted all other options. Let that be known. So deferring these types of decisions to the elected officials and saying, okay, this is really their deal, and we should just stay out of it, that's judicial restraint. Okay, that's judicial restraint. Okay, and both of these things can actually be very frustrating, especially if you're the side that loses here. All right. One other thing that I wanted to mention about all this was what was the interpretation of the Constitution, and that's one thing that isn't mentioned that I need to really get to. So look, if you take a higher level political science course, you're going to learn about a lot of things that have to do with interpreting the Constitution, and there's more than of these two ways that the Constitution can be interpreted. There's more than just these two ways. But I'm giving you the bare bones. Okay, we're scratching the surface here. And so with that in mind, we have what's called what's known as strict constructionism. And I'll get the word out eventually here. Strict constructionism. What this means is that you interpret what's there. Okay, you interpret what's there. You don't make it up. You have a rule of law, and you follow that. And you interpret exactly what is there. Okay? An example that they like to often point to, strict constructionists like to point to, is the Constitution. And a point of the Constitution is the Second Amendment. And I'm going to find one for you here as soon as I can. There we go. Where it says, it's the Second Amendment, and this is how it reads. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And so what they point to there is, see? It says, right of the people to keep and bear arms shall not be infringed. Okay? Shall not be infringed. You hear Senator Ted Cruz say this. You hear a lot of gun rights activists say that last phrase quite a bit. So there are extremes to every viewpoint. I want to be clear about that. But there are those who will argue to say that because of that particular verbiage, I can walk up and down Slide Avenue in Lubbock or on College Avenue in Levelland with a bazooka attached to my arm, and that's my ability to, I'm exercising my Second Amendment right. Okay? Agree or disagree with that, that's entirely up to you, but that's what some will argue about what that means. Strict constructionism, without a shadow of a doubt, is a conservative interpretation. Okay? It is a conservative interpretation. The flip side to strict constructionism is your book may call it broad construction. I ain't never heard of that in my life. And I don't refer to it as that, not even close. It's called the living document. It's called a living document. A living document means that the interpretation is based more on context of the law at the current time. So you can make the argument that living document is meant to adapt with society, that you adapt with the times. And so you can't always interpret what's there because the wording is too broad. And so what they'll often point to, what living documents will point to, is the Eighth Amendment. And this is how it reads. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. There ain't one daggone specific thing in there. What's excessive bail? What's an excessive fine? What's cruel and unusual? What's cruel and unusual 150 years ago is way different than what it is now. I can tell you that. And so when you get that mindset, when you look at things that are broad, you can only say, well, that has to go with the times. You can't just simply have it one way or the other. I mean, there is no strict rule there. Okay. Living document, without a shadow of a doubt, is a liberal interpretation. Okay. Make no mistake about it. And do note that the strict constructionist and the living documentist are in perpetual debate. They will debate each other till the cows come home, leave again, come home again, leave again, and come home again. All right? So there's no end result with these two basic competing interpretations of the Constitution. To be very objective here, Constitution that are vague, yes. It's up to you to what you do with them. Okay. That said, I want to move on here to some of the political implications about judicial restraint and judicial activism. Courts can be active. Courts can be restraint. They can do all that. But showing restraint and showing activism has nothing to do with the political interpretations. Okay? So just because a court is judicially active does not mean it's liberal. Just because it's judicially restrictive or showing judicial restraint does not mean it's conservative. We've had a conservative court here in the United States really since 1986, when William Rehnquist took over as being the Supreme Court Chief Justice. When then Chief Justice Warren Burger retired, Reagan made Rehnquist, who was an associate justice, the Chief Justice. And from that point on, we've had a rather conservative court. Okay? That said, has it shown restraint every single time? No. It has absolutely not. It has been an active court most of the time. We haven't had a liberal court since Earl Warren, who was the Chief Justice from the 1950s until the 1970s, till the early 70s, late 60s, early 70s. The Civil Rights Movement was the time whenever he was the Chief Justice. And was it active? Yes, it was. Was he liberal? Yes, he was. Were there times when he showed restraint? Sure. But that had nothing to do with his ideology. His political implications had everything to do with his interpretation of the Constitution. These next couple of things here from the slide, I want to talk about the Roberts Court and all of this sort of thing. I don't really have much room for this. I don't really have a lot of. I don't really want to spend a lot of time on this. So we're just going to move on from it. I'm not going to ask you any questions. We'll just move on from that. Now, a key question that we have to remember. is who checks the court after it makes a decision. Let's understand something about the checks and balances on the court system. They're all before someone becomes a judge. Okay? The president appoints, the Senate confirms. All right? All of that stuff is before someone becomes actually takes the robe and becomes a judge. All that's before. So what I'm telling you is this. How do we check it after the court makes a decision? How can we keep the court in check after? Constitution doesn't really say a lot about that. Truly. So this is where the checks and balances come in through their separation of powers. Not through the Constitution, but through their own capabilities. Now, one thing that is mentioned here that I absolutely despise, and I will not talk about this in any sort of great length, is what some have called, what your authors and other Supreme Court scholars will say, judicial implementation, meaning that the presidency has the ability to reject implementing certain laws. I don't buy that. I find that to be an impeachable offense. Okay, and I don't care what party that person's from. I don't care about any of that. If there's if there's a president who says, I'm only going to enforce the rulings that I like from the Supreme Court or any federal court, and I'm just going to ignore the ones I don't like, that is a dereliction of duty. All right, that's a dereliction of your oath of office. And I honestly think that's just me talking now. You're free to disagree with me, but most scholars and everyday people will say, yeah, that's an impeachable offense. You can't really do that. So we're not even going to entertain that thought. I'm just going to mention it, say it's out there. Some people think it, not me, and not this class. The real checks and balances on the court after it makes a decision have to come from Congress. Truly. They can. Your book talks about funding the courts, and that's true. That's true. The funding from the courts do come from Congress, and we always have to remember that Congress carries the purse. And so, with that said, what's that look like? Well, I don't know if threatening the court with funding is really going to get you anywhere, but I guess you got to do what you got to do, I suppose. I wouldn't pull that, but I'm not in Congress, and that's not me. But I will say what's more feasible than funding is passing laws. And what can happen here is if the Supreme Court rules a law unconstitutional, Congress can simply just take it up again and have another set of interpretation on that. That's 100% fine. That's been done several times. There is nothing new to that. I put up here revising old laws. So one of the big laws that was overturned, or at least in some manner, had to deal with Lilly Ledbetter and her case against Goodyear. And you can look into this, but because of the fact that she didn't get her back pay because of the statute of limitations with the law, one thing that happened was that it was the first bill that President Obama signed into law was the Lilly Ledbetter Act. That essentially overturned that Supreme Court decision through an act of Congress. It said, yeah, you can't do that anymore. Of course, really the best way to do it, and it's really the most difficult way to do it, is through constitutional amendments. That way, there is no interpretation. It's actually in the Constitution. Like, I mentioned this in class a couple times, called Texas v. Johnson, the free speech case dealing with flag burning. As soon as, and I made this joke and no one laughed, but as soon as Texas v. Johnson was decided, and it was decided that flag burning is a protected form of free speech, that Congress wanted to start to define what flag burning is and how it can be upheld in some manner or whatever else. What the proper way to burn a flag is. And so they were going to propose what's called a flag burning amendment. Well, that started out with a lot of fanfare, and it got some notoriety. Then after about a couple weeks, it all just kind of dwindled away. It didn't go anywhere. That was the end of it. So, because constitutional amendments, proposing them is really it's really difficult, because you got to get 2/3 of your chamber to do it, then you got to get 2/3 of the other chamber to do it. That's really hard. That's really difficult. So that's why constitutional amendments are such a big deal. I mean, we've been under the same Constitution since September 17th, 1787. Okay? That is 237 years. All right? Close to it anyway. When we get to September 17th in the next semester, it'll be the official time. But we only have 27 amendments. So these are big steps. But that is something Congress can do. It's a very, very heavy lift, but they can definitely do that. Congress can definitely do that. I put up here public opinion. Do note that these justices have to live here. Okay, they have to live here. They live under their rulings, so they see what they do, and it's not always fun when they make a ruling and it's not exactly popular. They know that. But what we also have to remember is that these justices aren't really big on starting revolutions or starting movements. They like to rather allow them to happen or stop them from happening. Okay? That's really where they are. And has that stopped them from doing something like that in the past? Well, no, it hasn't. But truth be told, that's where they've been. That's kind of their mindset. Some judicial traditions and doctrines. One thing that I mentioned before is that you have to have a real situation. They don't deal in the hypothetical, so you can always just really forget that. And that's really the one part of that I really want you to pay attention to. A couple of summaries here that I think would be kind of cool for you to examine and to really look at is, the sources of American law, being able to describe the structure of the federal court system and jurisdiction, standing to sue, all of those things, and we look at the other procedures of the U.S. Supreme Court and controversies and all that. I think that is very important for you to examine. And folks, I do have a parting thought here, but it's not exactly great important for your lesson, so we're just going to really just skip it. And that's going to be the end of this particular lecture. This is the last one. I do think it's important that we remember Federalist 78 here. So that is something that we have to really remember. Wouldn't be a bad idea if you went back and checked out your notes from there, because there will be a question or two about that on your exam. Also, don't forget about the extra credit opportunity. And I hope to see you then. Okay? All right, folks. Thank you very much.